Hi, my name is John Griffith. I'm a divorce and family law attorney here in San Diego, California. This is one of a series of videos aimed at addressing common issues that come up in California divorce and family law cases. I should note that nothing I say is intended to be or should be taken as legal advice. Every family law case is different, should be viewed on a case-by-case basis with a family law attorney of your choosing. I offer free consultations at my office. I'd be happy to speak with you about your particular case. Feel free to give me a call and set up a free consultation. Today I'll be talking about prenuptial agreements or premarital agreements. You want to get married and you need a premarital agreement or a prenuptial agreement. And you want to know how to write one that's going to be enforceable down the road. Worst case scenario, you have to end up using it. Hopefully you don't end up getting divorced, but you want to make sure that you have a premarital agreement that's valid and that's going to be effective. California law is very, very protective of the spouse that's entering into the premarital agreement, that the premarital agreement would potentially be enforced against. And so California law makes the drafter of the premarital agreement jump through a lot of hoops to make sure that the other potential spouse is protected. And I'm going to run through some of the things that you can put in a premarital agreement and some of the things that you cannot put in a premarital agreement. Now, the first thing you need to look at when drafting or having an attorney draft your premarital agreement is what you want to protect and what issues you want to include. And you have to understand what the law says about marital property to figure out how you need to arrange your premarital agreement. And what the law says is that once you get married, if you don't have a premarital agreement, between your date of marriage and your date of separation, with a couple of exceptions, everything that you acquire during that marital period is divided in half when you get divorced. It's called community property division. So once you have that basis, which your family law attorney can explain to you in more detail, you can write the premarital agreement to change the way the court is going to handle the issue of property division. So if you want your earnings during the marital community to remain your own separate property, where they otherwise would become community property, then you need to include that provision in your premarital agreement. Now, you can handle the issue of property division, how the court will look at community property. You can handle the issue of income in a premarital agreement. You can say that all of my income will remain my separate income and it won't become community income. You can handle the issue of debts, which debts will be assigned to who during the marriage. You cannot address the issue of child custody or visitation in a premarital agreement. That's an invalid clause in a premarital agreement. You cannot address the issue of child support in a premarital agreement. You can't address the issue of religion. So you can't include a provision in a premarital agreement that says we will raise our kids in a certain religion. It's invalid. It's contrary to public policy. One of the things you can include in a premarital agreement that gets kind of sticky is the issue of spousal support or alimony. And like I said before, the courts are very, very strict in protecting the person that the premarital agreement may in the future be subject to. If you want to include a limitation on spousal support, you need to make sure that your spouse or your soon-to-be spouse is represented by an attorney. If your soon-to-be spouse is not represented by an attorney and you want to include a provision for spousal support, that provision will be deemed invalid once you want to enforce the agreement. So be absolute certain that your soon-to-be spouse is represented by an attorney. As a matter of fact, I won't even write a prenup for a client unless the other party is represented by an attorney, regardless of whether or not a clause for spousal support is included. I think that if you want a lock-solid prenup that the courts aren't going to be able to attack in the future, you're doing yourself an injustice if you don't require the other party to hire their own attorney. Now, that said, even if your soon-to-be spouse is represented by an attorney, and you include a spousal support provision that says that that spouse won't receive spousal support or that spouse's spousal support will be limited in some way, the court could still down the road find that that provision is unconscionable and set it aside. So it's impossible to include a provision to limit spousal support or alimony that's absolutely rock solid. California law simply doesn't provide for it. Now, there's a lot of other things that go into drafting a valid prenup. It's covered in the family code and case law. I'd be happy to discuss it with you. If you need a prenup, if you need a valid prenup drafted, call my office for a free consultation. I'll run you through the requirements of a prenup and draft a good prenup for you. Again, my name is John Griffith. Call my office. It's Griffith Law, located in Solana Beach, California. I look forward to hearing from you soon.